that to the members, and also to prepare an annual return that I just mentioned earlier on, and submit it to the Labor Commissioner.
Okay. Mrs. Shuveni, from you we would like to find out, when should a trade union or an employers organization submit its annual return to the Labor Commissioner?
It's a good question. The trade union or an employer organization is required to submit a report, which is called a financial report, to the Office of the Labor Commissioner upon the end of its financial year. Where is this financial year indicated? This financial year is indicated in the Constitution of the Trade Union.
Okay.
That by this period of time, it's my end of my financial year, and I will submit an annual return. And that annual return includes the income, the money that is coming into the organization, as my colleague has alluded, that is the membership money, including the donation that can be received by any organization who feel like, let's donate to this trade union, and the money that also expended, expenses of that trade union should also be indicated, and the saving that the trade union made for the purpose of its finance. So these are the requirements that is needed in detailed financial report that is needed by the Office of the Labor Commissioner.
Okay, okay. Mr. Nasheko, who should audit the books of account of a trade union or an employer organization?
Okay, the books of a trade union or an employer organization shouldn't be just audited by any accountant or audit, but it should be audited by a public accountant and auditor, who then should be registered with now the Public Accountant and Audit Act. Yes, or any other audit or accountant which may be approved by the Labor Commissioner.
Okay.
Yeah, not just any accountant to do this. No. Should be registered with their body. Yes.
So basically, it is an accountant that is registered or appointed by the Labor Commissioner. So what they do is, what the trade union is then required to do is to hand over its books to the Labor Commissioner, who then appoints the auditor, or is it?
No, it's not like
that. Is it the trade union who now, or the employee organization that looks for this auditor but just needs to find out whether or not they are approved by the Office of the Labor Commissioner?
Yes, it's like that. There is a list of public accountants and auditors who are registered with the Public Accountant and Auditors Act.
Okay.
So the trade union must confirm if the accountant or the auditor that they choose is registered with the relevant body. Or if it's not, it should be now approved by the Labor Commissioner to do such auditing.
Okay.
Yes.
Okay. As we say, we educate, we clarify, and we always welcome you to ask your questions where necessary, where you feel that you've got a pending question that you would like to answer. We bring the necessary people and individuals and experts in the various industries closer to you using this platform. And you can always be part of the conversation through our various platforms, which is our social media platforms. On Facebook, you can find us at Ministry of Information and Communication Technology, Republic of Namibia. Ministry of Information and Communication Technology, Republic of Namibia. We are also live on our YouTube platform, MICT Namibia. MICT Namibia is our handle there. Our call line, you're welcome to call us in the studio, is 061, that's the area code, 400397 is the number in the studio, 400397. 061 is the area code. While we wait for you to join us here on this particular topic, we continue with the questions and would like to find out from Mr. Nanjihwa, what will happen if the trade union or employer organization fails to submit its annual returns?
So if the trade union or registered trade union or registered employer organization fails to submit the annual returns to the labor commissioner, the labor commissioner must notify such trade union or employer organization in writing to say that he or she has reason to believe that they are not complying with the provision of submitting the annual returns. So in such notice now, the labor commissioner must give opportunity to the registered trade union or employer organization to make a written representation on such failure, to say why they are not submitting or why they didn't submit. Then thereafter, labor commissioner will consider the submissions and then give feedback to them, to either a registered trade union or registered employer organization.
Okay. Ms. Shuveni, what then happens after this consideration of representation is made, yet this particular body, whether it's a trade union or whether it's an employer organization, still hasn't complied with this particular task?
Non-compliance after the engagement with the Office of the Labor Commissioner in terms of representation, whereby trade unions are required to, or employer organizations are required to submit, to come and do their representation, pardon me, in order to state facts as to why they failed to submit the trade union. After that, the Labor Commissioner will issue a document that is called a compliance order, accompanied by a letter that is also guiding the specific trade union or employer organization as to what are the shortcomings that the trade union and the employer organization need to address in order to comply. That is what happened after failing to comply.
Mr. Nashiku, now again, what then happens if a trade union or an employer organization fails to comply with the compliance order that has been issued?
Okay. You see, basically, the trade union or that specific employer organization was notified, listen, you are failing to comply with your obligations, was issued with a compliance order, as you should now comply. Now, in case that now you fail to comply with the compliance order, what the Labor Commissioner will do, we either cancel its registration or now apply to the Labor Court for an order to compel now that specific trade union or employer organization to comply with the compliance order. And in that order, they may be given an order to cancel, to suspend its registration pending its compliance. So your registration is cancelled for now until you comply with what you were ordered to comply with.
Okay. Yes. But now my question that comes thereafter is there I don't know, is it a fine that is attached to all of these non-compliances? Is there, for example, if this goes as far as the court, does the union then carries the court fees for that? And also, what are the rights of the members of that particular union? Because now you spoke about the registration of this union being at threat if they do not comply. What rights do the union members, those that actually pay the monthly fees and so on, what rights do they have? What are they allowed to do or not allowed to do with regards to a situation like that?
In terms of the provision of the Labour Act, the members of a trade union or employer organization, they have the rights to either, because even, let me say, such trade union, if it's registered, whatever it's guiding that organization should be availed or be available to the members in order for the members to know what are the guidelines that is guiding them in terms of the constitutions, in terms of their policy. So in case now if the trade union or employer organization is not fulfilling or working according to its mandate, so they can approach the labor court so that the labor court can give some directions. So that's what will come even in my what I'm going to educate on the other question that you're going to ask. But
Okay.
they have the rights to approach the labor court so that the labor court can give some direction
Okay.
for such trade union or employer organization to comply with the provisions of the Labor Act or the provisions of their constitution.
Okay. Okay. Now, I think there was a second part to that question. Are there any monetary consequences?
The consequences that is there, it's only for the trade union to be, or employer organization to be deregistered
Okay.
or to be suspended. That is now at another level of the court. For it to be suspended or for it to be, like my colleague alluded on.
Okay.
Yeah.
Then it brings us to that particular question that you were referring to. What will be the consequences if a registered trade union or employer organization fails to comply with any provision of its constitution?
So if a registered trade union or employer organization fails to adhere to the provisions of their constitution, so the labor commissioner or a member of such trade union or employer organization might apply to the labor court in order for the labor court to direct such trade union or employer organization to comply to the provisions of their constitution. It also, the labor commissioner or the member of a trade union or employer organization may apply to the labor court also for the labor court to cancel the registration of the trade union or employer organization. If it's has to do with the violation of the erection of the members of a trade union or employer organization, this is what we call now the office barrier. Then the two bodies, the labor commissioner or the member of a trade union or employer organization, might apply also to the labor court for the labor court to give some direction or even to nullifying the results or the outcome of such election or any order that the court might see it's relevant to such action.
Okay. We spoke about this particular body being suspended if they reach a particular level of compliance and the labor commissioner feels that it is valid for them to be suspended. Is there a particular time period that is attached to the suspension?
In terms of the provisions of the Act, there is no specific statutory time period that is specified. Maybe that will be to the discretion of the labor courts. Then it will be taken from there. But there is no a specific period of time, statutory specific period of time to say this is a time for suspension or whatever.
Okay. Ms. Shuveni, something similar, but this is more to the deregistration. If the labor court has, not labor court, pardon me, the labor commissioner's office sees it or deems it fit to deregister this particular body, are they then allowed to re-register at a later point? And what are the conditions under which they would be allowed to re-register if they are?
The understanding is that if the trade union or employer organization's constitution is deregistered, that means that the certificate of registration that has been issued previously is ceased. Now the following step that they have to follow, should they be again willing to to be a trade union or an employer organization for that matter, it's just to follow the step of initial registration, whereby they are required to comply with the provisions of the law as a new applicant for registration of a trade union or employer organization.
Okay. Mr. Nashiku, Ms. Shoveni's answer now brings me to the next question, where you've had whether it's a trade union or whether it's an employee organization, where they have been deregistered before. Let me call it repeated offender, if I can, for the lack of a better word, where they have gone through the process of being suspended before. They come back, they fix what they need to fix, they stay on the line. Then at some point they repeat again, they are deregistered, they sort themselves out, they are re-registered again, and then again they go through the non-compliance period for another term. What then happens to a body like that? Is it just a repeated cycle that they can repeat or continue going through? Or is there a point where things are, where a line is drawn?
Okay, you see, basically, when the trade union is cancelled, and then they apply for a new trade union, the only thing that the record that we are having is that a certain trade union or the employer organization known by the name was cancelled. But when they are applying now for the new name, what we are having maybe is that we are having the same founding members that we can link now to the cancelled trade union. But the act itself is silent on that. So there is no provision that outlines that if a certain trade union or employer organization is cancelled, and now you see where a new trade union is being applied to be registered with the name office bearers, we should put a link frame on that. The act is silent, and we should get a guideline from the act.
Okay, but what if the name still stays the same? What if, because there is, if I understand correctly, there's nothing against the same union coming back to re-register under the same name with the same members or founding members or leaders or so on. So what if you have the same trade union with the same name, with the same members, repeating the cycle? Is there a line? So it's still the same as Mr. Nashiku alluded to now. We have no guidelines of what we can do about it. Mr. Najihwa?
You know, there is a consequences. You know, when a trade union, let me just talk of a trade union or even an employer organization registered. So they have some commitments, obligation. They sign what we call, if a trade union recognition agreements, whereby they have to represent its members. They have signed those agreements 3 years. Now imagine if a trade union where it represent majorities in the country, then when it deregistered, which means it does not have any rights to negotiate or to approach the employer because it's not legal.
Yeah.
So if there is no such a trade union employer organization want to go to such extent, but if it happened to be deregistered, when it apply for registration, the same name, the same members, that would be not an issue. But if they still not comply, then the same procedures will be just followed. Unfortunately, like what he said, there is no provision that to say this is a cul-de-sac or this is a point whereby we can entertain. But like we are speaking, there is an amendment of the Labour Act that is ongoing. Hopefully, there will be some those terms and closure that will be guiding us further.
Okay. It's as I always say, we learn new things, and there we have it, that something like that, you know, can come up, and maybe we or this platform can also help our Office of the Labour Commissioner to say, you know, there's a loophole here. What is the possible mitigating, you know, method to try and deal with it? And with that said, we have come to the end of our show this afternoon. from myself, Shianwa Desire Kahiha. I believe that we have really covered a lot with regards to trade unions and so on. But I would like our panelists to give us their last remarks for this afternoon. Mr. Najihwa, we start with you.
No, I would just like to say that a registered trade union and registered employer organization, it's an organizations that are dealing with public or members' resources. So now, if they are not submitting or if they are not giving reports on how are they use that money or resources of the members. So at some point, the member might lose interest in them, or the member might, just to say, they might not know what is their money or what is their resources that they give to them, or what they are contributing monthly to say on what they are using for. So it's very important for such to be, for the organization to have records on such. And just to add again, maybe if now a trade union and organization deregistered, so it will affect members, because workers, they are suffering there. So at least if the trade union is there, at least it's the voice of the workers. And if the employer organization is there, it's the voice of the employers.
Yeah. Very good point there. Mrs. Shuveni?
In conclusion, I just want to make the public aware that the trade unions' money or employer organizations' finances belongs to the members.
Yeah.
And it should be utilized to the benefit of the members.
Yeah.
Not only for representation, it's also to acquire property for the union, in order to have equipments, union equipments, and also to have buildings, to have an office that is existing in public, that is indicating that this office belongs to so-so trade union, and that is the benefit of the members. And I also want to indicate to the interested parties and the office bearers of trade unions and employer organization to take care of this money. And at the end of the day, they must be accountable to all expenses, and also to be transparent to the members to know. Because these financial reports are not only required to be submitted to the Office of the Labor Commissioner, as it is stipulated under the law, but it's also supposed to be known by the members, for the members to know how their funds are utilized for their own benefit.
Thank you very much, Mr. Vene. It's true. The union belongs to the members, and transparency would actually allow for a stronger confidence by the members in their union, leadership. Mr. Nasheku, your last words?
Yes, my closing remarks for today, it may be on auditing. Because it's something that we pick it up that when the trade union or employer organizations submit their annual returns, not all, but some, the statement or the report have been prepared by auditors or accountants who are not registered by the relevant body. So it's up to them now that before they approach, maybe they can confirm with us, I want or I approach a certain audit or accountant to do my auditing for me. Are they registered as per their act, or is it an approved auditor or accounted by the Labor Commissioner before they proceed? Because we notice there are some, yes.
So basically just trying to ask the trade unions or the employer organizations to do their due diligence. So I believe that also helps to not delay the outcomes of that particular report. Okay. With that, we have come to the end of our show. We'd like to take this moment to say thank you very much to our panelists for availing their time to help us to educate not just ourselves, but you as well out there and have these conversations with us. From myself, Shianwa Desire Kahiha, along with my production crew, it's bye-bye until tomorrow.